My name is my name is Tony Smith. I'm Vice President of GAE Retired, and we present this seminar quarterly so that those of you who are looking forward to retirement, no matter how far away it is, will have the tools that equip you to make good decisions. We are going to begin today with legal matters presented by Kelly Napier. Kelly, help me. Napier, right? Okay, Kelly Napier, certified elder law attorney, Georgia Estates and Elder Law, LLC. And Kelly is our friend from way back. And we are so glad to have Kelly back with us today. So I will turn it over to you.
Awesome. Thank you, Tony. So I am Kelly Napier. I am an elder law attorney. Elder law, I tell folks, estate planning is planning for after you die. So we do that, wills and trusts. And elder law is planning for while you're alive. So we focus a lot on powers of attorney so other people can manage your finances and advance directives for healthcare so that other folks can talk to your doctors and make sure your wishes and your needs are being covered. I am very open to folks coming off mute and asking questions while I talk. My only request is that your question be something that other people care about. So, a question about your cousin or your spouse is not the question that other people care about. A question asking for more clarification or what's probate or tell me more about power of attorney, those are the kinds of questions that everybody cares about. So that's my only piece is let's make sure it's a general question for everybody. But other than that, feel free to come off mute and ask questions as we go. So the most important document that all of us need to have, because I feel confident saying everybody on this call is over age 18, is a financial power of attorney. So, a financial power of attorney is a document that lets you give somebody else the authority to sign things and manage legal affairs and manage financial affairs on your behalf. The document is only as good as the things it says in it. So, our state legislature updated our power of attorney law in 2017 and again in 2018. And we now use what's called the uniform power of attorney. So us and 39 other states all use the same basic form. And it includes a ton of powers. It includes everything from banking to taxes to doing planning to be able to be eligible for benefits like Medicaid or veterans benefits in the future. So there are a lot of powers in Georgia's financial power of attorney. If you have an old power of attorney that's older than 2017, it's probably a good idea to update. There's a few reasons it's a good idea to update. The first one is your life may have changed in the last 8 to 10 years, and you may have different people who should be listed as your agents. The other reason it's a good idea to update is if you use the new form, and new is relative, right? Since 2017, then your agent has got some extra powers and protections that they don't have if you're still using the old form. So your old power of attorney is totally valid, but if you're on the new form since 2017, banks have to accept the form when your agent shows up to try to get access to your bank account to pay your bills. So, if anybody has done any of this for their parents in the past, you may remember going to the bank and they say, "No, bring your mom up here. She's got to sign our form to give you the power to do any of this." Those days are over. If you're on the new form, then the bank has to accept it. Their only other option is call the police and report you for fraud, which they do that too. But I'm kind of thankful that they are doing that. That's always been their job is to protect their bank customers. And now with the new statutes, we've made it more clear that that's their job, and we've made the banks start paying attention and start reporting fraud when they see it and start involving the police when they're worried about a client being exploited. And so banks are doing a better job. Excuse me. Um, so financial power of attorney, most important thing. My number one advice for financial power of attorney is do not use a free legal website. This is super important. I don't know, do y'all have a legal plan that you can offer to your members? No. Okay. That's okay. Those plans aren't awesome. Um, but uh don't use a free legal website. Use an attorney. If you cannot afford an attorney to help you with your estate planning, Emory School of Law has the financial power of attorney, the correct form, on their website for free. The problem with those free legal websites is they usually have 7 or 8 different documents on their website that you are supposed to pick between. And you probably don't know exactly which one is the current statutory form, the current form that our state legislature has created. And what I've seen over the last 5 years is that people usually pick the form that was valid in Georgia before 2008 and references laws that were repealed. And so when you sign that form, you haven't given any powers because there's no laws that use those statutory numbers anymore. And so don't use free legal websites. Use a lawyer, or if you truly cannot afford a lawyer, Emory School of Law has the financial power of attorney on their website. The reason this is the most important document is what happens if you don't have it. If you don't have a financial power of attorney and something happens to you, and and you cannot manage your own financial affairs, your loved ones have to go to the local probate court in the county where you live and petition the court for conservatorship. So they have to tell the court that you can no longer make or communicate significant responsible decisions about your financial and legal affairs. That's a big deal because if the court agrees with them, the court takes away your authority to be an adult. You can no longer vote. You can no longer get married or divorced. You can no longer own a gun. You can no longer manage your own checkbook or access your own bank account. You don't get to make any legal decisions or financial decisions about yourself if your family has to go to the probate court and get conservatorship of you. There's no default where some family member has access to your accounts. And people always stop me right here and say, but I'm married and my wife or husband is on all of my joint accounts. Well, that's great. That means that they can access those accounts. It does not mean that they can contact TRS on your behalf and change where your direct deposit goes. Or talk to your health insurance company about your health insurance coverage. Or contact TIAA to take distributions out of your 403(b). They can't do any of that without a power of attorney. So it's more than just writing checks on your checking account. So, power of attorney, most important document. Conservatorship, bad for you because it takes away all of your powers. So, let's get a power of attorney in place where you still have power and you're sharing it with other people. Conservatorship is bad for your family because in most of Georgia, it takes 3 to 4 months to get through that process, which means they don't have access to your funds and can't sign things for you for 3 to 4 months. So you're just kind of in limbo, hoping people let them work around or use their own money to pay your bills for a while. Another reason it's bad for your family, the court fees are between $500 and $800 to file this petition. If they hire a lawyer, the fees usually start at 5,000. You don't have to hire a lawyer to do it, but it's expensive. And so avoiding that by signing a power of attorney, most important thing. I saw one question and it's not about this, so I'm gonna not answer it yet. But are there any questions about financial power of attorney?
I have one question. So
Yeah.
basically, in order to get the financial power of attorney, you need to pretty much get legal counsel as far as a lawyer. And
I highly recommend it. Yes.
and I guess my other question is, even though if you have a joint account and the person's name is on there and you probably, you can't speak or anything for yourself, um, as far as like the TRS and all that. So if I had the financial power of attorney, they would be allowed to contact TRS and do all of that. So if I didn't have that, then I'm pretty much screwed as far as if they need to change the banking information and everything like that. So is that, am I
Exactly.
understanding that correctly?
That's exactly correct. I'm gonna
Okay.
let you sell powers of attorney next time.
Oh, okay. I just wanted to make sure because I mean, like, I've got my like brother's name on my, checking account and all of that, but I don't think I probably need to go back to my lawyer because I don't think I have a financial power of attorney to make
Yeah,
sure, if anything happens, he could speak for me as far as, teacher retirement and anything else I have. So, okay.
exactly.
Okay.
Yep, and that's the concern, and that's why it's so important.
Okay. All right. Thank you.
Yeah,
Patrick.
Patrick, what's your question?
Hi, everyone. I'm president for GAE Retired. I want to welcome everybody. In fact, that's what I'm dealing with right now. My mom had a stroke and she has 4 kids, and we're working. But I'm in Texas right now with her, and it's a little bit different. Her, we've got everything else tied up to where it won't be a problem if something were to happen. But right now, because mom's struggling, we went to the credit union where her majority of her money is, and we got my youngest brother has got the power of attorney over all of her accounts, and I'm on her main account with her so I can write checks. That's Is that possible to do something similar to that in Georgia
Yep,
to
power of
help out?
attorney works the same nationwide. And
So
so
I mean, we didn't have to go to and get any of, we just went to the credit union and filled out a few forms, and they called and checked with all of us kids and make sure that it was all right for him to be the power of attorney.
then that's
So
not
we,
power of attorney. So power of attorney, mom has to sign a document that says that she's giving your youngest brother the authority that so if you did something other than that, he doesn't technically have power of attorney. If the bank or the credit union worked something else out with you, that was their internal policy. Power of attorney means mom signs saying, I'm okay with somebody managing my financial affairs. Yeah.
but that is an alternative, but you have to be real careful and make sure you know what you're doing. So I
Yeah,
guess is what I'm saying.
okay.
But thanks.
Yeah. All right. Tony, did you have one question before I move on to the next thing? All right. So the next thing we're going to talk about is advanced directive for healthcare. So whereas on the financial side, you've got to sign a document or nobody's got powers. On the healthcare side, in Georgia and in most states, we have what's called a next of kin statute, which says if you have made no plans for who's making your healthcare decisions when you can't, then it's your next of kin. So it's your spouse if you're married. If you're not married, it's all of your adult children. So I shared um, earlier that my dad's in the hospital right now. He's married, so my mom is his primary decision maker. If she weren't here, my dad has 4 adult children. 2 of us are here and involved, 2 barely even know he's in the hospital. And we would have to agree with them about his healthcare decisions. And my half brother, who is my dad's stepson, who is here and involved, would have no say. So in our family, we have advanced directives for healthcare that lists my mom and then the 3 of us kids who are here in order of both who's most likely to be there and who has the most knowledge around these issues, right? So that we've got a clear pecking order of who's making those decisions based on skill and availability. And so Advanced Directive for Healthcare is in Georgia. It's our healthcare power of attorney and our living will, and it's a HIPAA release. It does all sorts of stuff. But really, it gives you a place to name a healthcare agent, somebody who can talk to your doctors. It gives you a place to tell your healthcare agent what kind of end of life healthcare you want. So specifically, the Georgia form says if you're terminal and going to die in a relatively short period of time, or if you're in a persistent vegetative state, what kind of life support do you want? That section is advice to your agent. So I had a family in my office this week. The husband, this has been 4 years ago when COVID was at its height. The husband had COVID in the hospital on a ventilator, and the doctors realized there was nothing more they could do, that they did not foresee him surviving. And came to the family and said, we think he's going to die relatively soon, even with the ventilator. So let's disconnect the ventilator and give it to somebody else. And he, in a miracle of all miracles, happened to have a close family member that worked for a company that was doing an experimental drug trial, and they got him on the trial and it worked, and he survived. His healthcare directive said, if the doctors say I'm terminal, go ahead and disconnect me. That was advice to his wife, who was able to make a different decision for him. And it worked. He was in my office last week. He survived because of his family member being able to get him into a drug trial. But that's a great demonstration of the advice you give in the healthcare directive is not binding on anyone. It is just advice to your family or your healthcare agent. It's up to those folks to make the best decision for you. So make sure you've got the right folks, right? My dad's healthcare directive does not list his two sons who don't live here and don't know anything about his health. My healthcare directive at the beginning of my marriage did not list my wife because she wouldn't have done what I wanted. Now we've come to, well, she's come to believe what I believe. And so now she's my healthcare agent. But she wasn't for a very long time. So, I realized when I updated my healthcare agent that I had named my mom, and she wouldn't have done what I wanted either. So when I updated it and made my wife the first person, I've already told you I've got 4 siblings, 2 living parents. I didn't name any of them as the backup. I named my ex-sister-in-law because she's the person who I knew would do what I wanted. And I sat down with her and I had the long talk with her about what kind of healthcare I would want and made sure, even though it might not match what she would want, that she understood and would be willing to do what I would want. So that's super important on the healthcare side, is make sure the people you named would do what you want. Another part of our healthcare directive here in Georgia is you get to designate whether you want to be buried or cremated. We've got legally 2 other options in Georgia. Practically, we don't have funeral homes doing them, so it's buried or cremated here. So if you want to be cremated, you need to have a healthcare directive, name a person as your healthcare agent, and initial cremated on the form. So I talk about my family a lot. I'll continue that trend. My grandmother passed 12 years ago. She had been a hospice volunteer. And so she understood the purpose of pre-planning. So she had been to the local funeral home. She had planned her entire funeral. She knew she wanted to be cremated. She had listed what ladies at church were going to sing which songs. She did the whole thing. And then a couple months before she died, we realized, well, we don't know which funeral home she did that at. There are 2 funeral homes in her town. So we went and we figured out which funeral home it was and got a copy and found out, although she planned the whole thing, she didn't pay for it. So we paid for it. We paid for her funeral about 2 months before she passed. She passed. We called the funeral home. They came and got her body. All is going well. A couple hours later, they called us and they said, okay, we need all of her kids to come sign before we cremate her remains, because cremation is permanent and they can't undo it. So they got to make sure it's the right thing to do. And we were like, not possible. There's no way we can get one of my uncles here. In fact, it took us 9 days to get him here, and he knew that my grandmother was dying. And so we were like, not possible. What else you got? And they said, well, did she have a healthcare directive? Yes. Great. The agent on her advance directive for healthcare can come sign this afternoon, and they were able to cremate her that evening. So it's huge to have a healthcare directive. It just makes everything smoother when we got somebody empowered and in charge. If we don't have a healthcare directive and we're in that next of kin law, and Dr. Rhodes, I'm going to use you for an example, and I'm just making assumptions because you told me you have your brother on your bank account, which makes me think you're not married and you've got no kids.
Correct.
And let's say you've got 4 siblings like I do. Siblings fight more than adult children do about each other's health care. The worst fights I see are between siblings deciding healthcare decisions for each other. If they don't agree, you stay on life support indefinitely until one of them goes to the local probate court and petitions for guardianship. So, guardianship is the legal process for the judge to appoint someone else to be in charge of your health care and your living situation. And so, Dr. Rhodes, I'm going to keep using you, and I apologize. When you go back to your lawyer for the power of attorney, you also want them to help you complete an advance directive for healthcare so that you can make sure your brother is that one person who's got the power. And then we're going to put backups on. So if he's not available, who's the backup to be able to make those decisions for you? Guardianship, the other reason, besides just not having documents, that sometimes we have to get guardianship of people, is people who have cognitive impairment, generally some sort of dementia, and don't understand don't understand the consequences of their decisions around healthcare. So, the legal standard is that you cannot make or communicate significant responsible decisions about your health and safety. So we all get to make bad choices. And I'm sure we all know somebody who said, I'm only leaving my house feet first, meaning I will continue to live in this house until I die, right? We all know those people. And everybody has a right to make that choice for themselves. And if they don't understand the consequences of the choices that they're making that could cause them to die in their home, potentially alone, then we might need guardianship for someone else to exert their power given by the court to move them to a safer place. So I tell folks the easiest example I've been able to come up with is food in the fridge. If you've got somebody who's eating rotten food because they don't have fresh food in the house, and they know that the food is rotten, and they are either used to it or just that's what they have available, and they don't know how to get other food in the house, that's not incompetence, right? That's somebody who knows, they understand what's happening. If you have somebody who's eating green yogurt and they don't understand the green yogurt is why their stomach is upset every day, that's incompetence. That person would be eligible to have a guardian move them somewhere else where they could have fresh food available to keep them healthy. So you can make bad decisions as long as you understand the consequences of those bad decisions. We don't have to let people who don't understand the consequences live with their bad decisions. We can step in for the folks who don't understand. Questions about healthcare?
I just have one question for clarification.
Yeah.
So I have 2 brothers. So if I didn't have the health directive or whatnot and everything, so I guess it would fall into like the next of kin, and both my brothers would have to be the decision makers. They would both have to come to an agreement.
Agreed.
I didn't have the directive with everybody's name listed. Am I understanding that correctly?
Right. Yeah. So if you didn't have a healthcare directive and you wound up in the hospital, your brothers have to agree, or else you stay on life support.
Gotcha.
Yep. That's perfect example.
Kelly, you said there were 2 options for disposal of a body, burial and cremation. Is body donation an option There are medical schools in Georgia. Is
Yep.
that an option?
Yeah, so when they finish with your body, they cremate.
All right, so you arrange that with the medical school.
You arrange it with the medical school. So we've got probably our biggest body donation program in Georgia is the Philadelphia College of Osteopathic Medicine. So they're in Swanee and then they're somewhere in South Georgia. I don't remember exactly where. They've got two campuses here in Georgia, and they have a huge body donation program. So if you just want to generally donate your body to science or research, I strongly recommend reaching out to PCOM, PCOM, Philadelphia College of Osteopathic Medicine. Um, Morehouse has a body donation program. It's quite small. Emory has one, but honestly, Emory is usually full. And often, even if you have signed up with Emory, they often will not accept your body when you pass because they don't need one at the time because they're so popular, basically. Um, so so if you have something interesting with your body, a rare disease or something different about your body, or even a common disease. I have a lot of clients with Parkinson's disease. The University of Indiana is doing research with brains of people who had Parkinson's disease. And so if you have some sort of interesting thing going on with your body and you want to donate specifically to a study for that, talk to your specialist who treats that and they will help you find a study for that thing. So I have a number of clients whose brains will be removed from their body and shipped off to the University of Indiana when they die because their neurologists were able to help them find that connection to that study. And there is a place on your healthcare directive to say, like, I'm okay with that happening. I'm okay with donating my body or parts to research, or I'm okay with organ donation, or I'm not. So you can say, I'm okay if you do that or don't do that. But if it's something you affirmatively want, you need to take some steps while you're alive and go ahead and register with either a research program or a body donation program. All right, let's talk about being dead a little bit more. So, your will is what most people think of as the document that manages things after you die. So, I'm going to start by talking about what happens if you don't have a will. If you don't have a will, then your family, back when we were talking about next of kin, is that same sort of levels, except spouse and kids are one level if you don't have a will. So your spouse and children inherit equally, but your spouse doesn't take less than a third. So I'm married, I have 4 kids. If I died today without a will, my wife would get a third, my kids would each get 2/9. That's not what I want. My children are little, they don't know what money is. I don't want them to get anything. I want my wife to get everything. So I have a will that leaves it all to my wife. So you don't have to have a will. It goes to your family if you don't have a will. But if you have a will, it goes to the people you've named in the will. So, Dr. Rhodes has got 2 brothers. It goes to her 2 brothers if she didn't have a will. So it goes to your legal family. I've got a client who passed away owning half a house. His parents and his brother all predeceased him. He has got, at last count, all his grandparents are dead, all his aunts and uncles on both sides are dead. At last count, I think he's got about 30 first cousins who are each going to inherit about 1/30th of his half of the house, right? He would have been better served having a will. So that's what the will does. A will also lets you set some parameters around what happens. If you die without a will, it's called intestate, and your administrator of your estate generally has to be bonded. So a bond is an insurance policy that's ensuring that they're going to do what they're supposed to do. Those can cost anywhere from 1 to 10% of the value of the estate. So they have to be bonded. Generally, they have to file inventories, which is a list of all your assets, and returns, which are penny by penny accountings of everything that went through your estate in the probate court. Everything that's filed in the probate court is public record. So this is why we know all those details about Aretha Franklin and Prince, is because they died mostly without wills. Aretha Franklin, the court decided she probably had a will, but mostly without wills, and so everything that got filed was totally public record. If you have a will, you can say your executor doesn't have to be bonded. You trust the person you picked not to steal from you. You can say that they don't have to file a list of your assets, or they don't have to file an accounting with the court. Your beneficiaries, the people who are inheriting, are still entitled to those things, but they don't have to make it public record. And the other big thing you can do with a will is you can include trusts for people. So I mentioned I got 4 little kids. My will says if my wife and I both die, that everything's going to be held in trust for our children, and their godmother is going to be in charge of it until they're older. Because little kids can't own things. If we died without wills, they would have to keep an accounting of how they spent every penny of my kids' inheritance until they turned 18. And then they get it all at 18, whatever was left. I don't want an 18-year-old having money. So I've got a will that holds it until they're older, that we can spend it on their health, on their education, on the things they need, on their living expenses, but that they don't actually get to control it themselves until they're old enough to do so. One of my kids is special needs. And so my will also has a special needs trust because when he turns 18, he's going to get Medicaid because he's not going to be able to work. And so for him, it says anything that goes to Jameson is being held in a special needs trust so that he won't lose his Medicaid benefits and won't lose his SSI benefits because he is going to need support for the rest of his life. So his inheritance will be there to help support him, and he'll still have his health insurance and he'll still have that SSI income coming in on a monthly basis. And so I include special needs trust in every will I draft because we never know when somebody might become disabled who's going to inherit from us. But when we know we've got somebody like my son, we intentionally do it. So, Patrick, I'm going to use you for an example. I know nothing about you, but I'm going to invent some stuff about you for a minute. I'm going to invent that you're not married and have no kids, but I know you've got a mom who just had a stroke. And so if you died, your mom would inherit from you. Because in my invention, you're not married and have no kids. And we don't want your mom to inherit because she might need Medicaid to pay for her care. Because of her stroke, she's more likely to need long-term care. And Medicaid pays for long-term care. Nationwide, 70% of people in nursing homes across the country are paid for by Medicaid. We wouldn't want somebody who's receiving that kind of care to inherit and lose their Medicaid benefits that are paying for their facility. So we say, Patrick, in your will, when we do it, we would say anything that goes to your mom goes in a special needs trust. So she doesn't lose her Medicaid, but she could benefit. Maybe it can pay for a private room. Maybe it can pay for extra therapy. Maybe it can pay for an extra caregiver to come and sit with her because you wouldn't physically be there anymore. Whatever that is that she might need, the special needs trust can pay for that. So that's kind of what a will is and how it works, and because some of the additional planning you can do inside of a will. A will goes through probate. So probate is the process where we transfer things from a dead person to whoever else they're supposed to go to. If you don't have a will, if you're intestate, they go to your family. If you have a will, they go to the people you named in the will. But nationwide, except maybe Louisiana, but the rest of the country that uses British law, the way it works is when you die, the executor of your will or the administrator, the person who's going to be in your estate if you don't have a will, files a petition in the probate court that's signed by your heirs. So your heirs are your legal family. So a petition in the probate court signed by your heirs, whether they're inheriting under a will or not, that says you've died. And either we all agree there's no will or we all agree this is the will. And then the court issues what's called letters testamentary, if there is a will. That's the executor's authority to do what the will says. Or letters of administration if there's not a will, which is the administrator's authority to gather things and distribute it to the heirs, to the legal family. That process varies. Here in Georgia, it's super easy. You can be all done getting through that first step, gathering assets, selling houses, distributing everything out where it goes. You can be all done in 6 months here in Georgia if you're working diligently on it. In some states, Florida, New York, California, that process can take years just to get through that legal process. In a lot of states, you got to have permission from the court to do each step, to sell the house, to distribute assets. And so a lot of folks choose to not do that, to avoid that whole process. And they avoid it by using what's called a revocable living trust. Revocable living trust is a document for you to create a trust. A trust is a legal entity that you're going to be in charge of. So trusts have 3 roles. The trust maker, the person who creates it, that's you. The trustee, the person who's in charge of it, that's you. And the beneficiary, the people who get stuff out of the trust, that's you as long as you're alive. So a revocable living trust is so much you that it even uses your social security number. So it's just like you own it, except this entity that you've named called your trust owns it. And the trust says if you can't be in charge anymore, if you're dead or you're incapacitated, somebody else is going to be your successor trustee, the backup trustee. And the trust says when you die, somebody's going to be the remainder beneficiary. Somebody's going to inherit out of the trust when you die. And the trustee doesn't have to file anything in the court. The trustee doesn't have to get permission from anybody to be able to distribute your assets in the way you've described when you die. So if you have a revocable living trust, it can still include those trusts for minors. It can still include a special needs trust for folks who have Medicaid or SSI issues. It can still include just ongoing trust. I've got several families lately who have very young adult children who just need somebody to manage money for them for a while. So it's not that they're little kids and they can't manage it, it's just that they need some help for a while. And so those adult children's shares are going to be held in just a trust for them until they can get the handle of managing it themselves. And then it'll pay out to them and they get to be in charge once their parents, at whatever age their parents have picked, that they're going to be able to manage it themselves. So the advantage of revocable living trust, you go ahead and title your assets now. So you sign a deed to your house that says, for me, my house goes from me to my trust. And now my trust owns my house. But my trust is me, right? My social security number, so it doesn't change anything tax-wise. I go to the bank and retitle some bank accounts in the name of the trust. I change the beneficiary of some of my retirement accounts or my life insurance to be the trust. And so everything's able to happen through the trust when I die, because the trust already owns everything. And so the goal when you're using revocable living trust is for everything to either be owned by the trust or have named beneficiaries, whether those beneficiaries be people or the trust. And then those things wouldn't go through probate. And so you can avoid that court process. I've got 5 minutes left, I think. I'm going to totally change topics. And somebody asked earlier, should I renew my present insurance if I retire in June? Yes, because you're going to need insurance until June. And then it looks like Mike with TRS is going to talk later, and he'll be able to tell you about what needs to happen in June when you do retire. But for now, yes, you do need to renew your insurance to have coverage until June. Does anybody have questions about any of the legal things I've talked about?
Yes, I have a question.
Yeah.
You mentioned with the revocable living trust, three
Mhm.
things, or three people, the
Mhm.
trust maker, the beneficiary. I missed the second one you
The
said.
trustee, that's the person in charge.
Trustee. I just wasn't writing fast enough. Okay.
Sorry.
That's okay. I had another question. It's kind of just me. When you deal with all of this stuff, where do you start? Like, which type of lawyer do you get? Where do you just start? I just would need a boost to start all this stuff.
Yeah,
If that
I
makes any
recommend using
sense.
an elder law attorney because I think we do a better job of the planning for while you're alive part, which to most of us matters more. But an estate planning or an elder law attorney, you can search for elder law attorneys near you. On our national association. It's NAELA.org. So NAELA.org. It stands for National Association of Elder Law Attorneys. You can
Okay.
search by zip code and find an elder law attorney near you. Um, but if you've got friends at church or just friends who know estate planning attorneys, they can do a good job with the will and maybe the trust part. And with some prompting, usually can do a decent job with the power of attorney or the healthcare directive as well.
Okay. Thank you so much. That helps so much. Thank
Yeah.
you. Thank you.
Kelly,
Yeah.
I cannot thank you enough for
Oh, my
all of
pleasure.
this amazing information. We have missed you. There is so much, so many moving parts to making sure that our business is in order before we retire, before we die, to make sure that our families are protected. So, thank you so much for giving us a boost. We hope we see you at the next seminar. I'll be in touch with you. And I hope your kids have a good time with the lizard.
Thank you. I appreciate it. Y'all have a good morning.
All right. Thank you so much. All right. Our next presenter is Jamie. Jamie, is your last name Lyell?
It is.
Oh, I'm so proud of myself. Jamie Lyell from AARP, and he is going to talk to us about Social Security. Now that the Social Security Fairness Act has passed, this is something that impacts all of us, thankfully, because we will receive our Social Security now. We are no longer under federal penalty. Um, so I have made you a co host, Jamie. See if you can share.
Yes.
Very good.
Awesome.
All
Should I
right.
take it? Should I take it away from here?
Take it away from here. That's what I was about to say.
Okay, thank you. Hello, everyone. Thank you for allowing me to join you today to talk about Social Security. Honored to be here on behalf of AARP. So let's get started. Now, I like to use some sport references, and I like to envision Social Security as your financial defense. So just like an athlete blocking a shot, it is there to protect you from unexpected hits or financial hits within retirement. And before we get started, I wanted to show a video about how ARP advocates on your behalf. Hello, I'm Jamie Lyell with AARP, and I just want to take a moment and share how AARP is fighting for you every single day. From the State House to Capitol Hill, we're on the front lines protecting Social Security and Medicare. We're pushing back against proposals to cut benefits or raise the retirement age. We're making sure lawmakers understand that Social Security isn't just a program, it's a lifeline. And when it comes to Medicare, we're working to lower prescription drug costs and make sure you have the affordable, high-quality care that you deserve. These aren't handouts, they're promises you've earned with every paycheck. And AARP is here to make sure those promises are kept. And if you'd like to stay informed or get involved, visit aarp.org/getinvolved and sign up for our free advocacy newsletter. One voice might get lost in the noise, but when a million of us speak up, Congress listens. So raise your voice and join AARP in making sure we're heard. Thanks for being here today and for standing up for older adults and future generations. Awesome. Okay, and moving forward. Today's agenda. Now, this workshop has been created because we are committed to helping you understand your Social Security payments. So in my session, I plan to discuss what is Social Security, full, early, and delayed payments, Social Security and work, popular topic, family payments, how to apply the resources, and the even more popular topic, the future of Social Security. So let's start with the basics. So Social Security was created in 1935 in the aftermath of the 1929 stock market crash and the Great Depression. Now, it is based on the concept of social insurance, which means that all workers contribute to a central trust fund managed by the government. Almost everyone contributes to the Social Security Trust Fund, and Social Security taxes are called FICA, F-I-C-A, which stands for the Federal Insurance Contributions Act. It's tax paid by employees and employers that fund Social Security and Medicare. The current tax rate for Social Security is 6.2% for the employer and 6.2% for the employee. That totals to 12.4%. And to be eligible to collect retirement payments, a worker must have worked for at least 10 years or have earned 40 credits and paid Social Security taxes. Now, the Social Security Trust Fund is used to provide payments to individuals who are retired, disabled, or are a survivor of a deceased worker. And Social Security was always intended to be a safety net to provide some income. It was never intended to be the only source of income, but despite this, many recipients are using it for most or all of their income. Now, I do have a quick survey, if you will, to get a feel for everyone, if you're able to drop that in the chat. But what would you think the average Social Security payment is for 2026? How many would think it would be A, $995, or B, $1,304, or last option C, $2,007? I think I do not have the chat right here to see it. Let's see here. I see a B, I see an A. Okay, so if you were thinking C, that is the correct answer. Now, that is the average for all types of Social Security payments. That's individual, spousal, survivor, and disability. And your own payment may differ considerably based on your own personal situation and what type of payment you are collecting. If it's for retirement payments, how much you will have paid into Social Security. So I want to go into when you can claim your retirement payment. You can choose to receive your payment as early as age 62, but your monthly payment amount will be reduced as much as 30%, and this reduction is permanent. And this includes any survivor payments you or your family may be eligible for. So it's important to consider how this decision will impact anyone who might collect on your record as well. I'm gonna go into each one. So starting at age 62, the earliest. Now you can start receiving your payments as early as age 62, but your monthly checks will be reduced. And waiting until your full retirement age or beyond increases this monthly benefit. Now, it does provide immediate income sooner, especially if it's needed, but it does come with those drawbacks. Again, that 30% reduction, depending on your full retirement age of 66 or 67. And I'll show a chart for that shortly. And this reduction, again, is for life. And I will discuss the break-even age on what it will look like versus 62 and different claiming ages once you reach 78. So next, waiting until your full retirement age, or FRA, you'll be able to receive 100% of your calculated benefits, no permanent reduction for claiming at your full retirement age. So waiting may pay off in the long run. I'll get more into that. That's that break-even stage. Now the drawback of this that you must have to wait till 66 or 67. Use some savings in the interim or maybe keep working, depending on your situation. And you want to consider your health and financial situation as well. Those personal factors do matter. And Medicare enrollment, I want to highlight, I'm not a Medicare expert, but I do want to highlight that if you are turning 65, you want to make sure that you enroll into Medicare within 3 months of hitting 65, unless you have a insurance plan through your employer or your spouse has an insurance plan, then you will not have to enroll into Medicare, then you can wait. And then delaying until age 70, I want to highlight also that this is the latest, if you will, that you can claim your Social Security payment. If you go beyond this age, there is no further benefit. So 70 is where it caps. And you'll be able to receive 124% of your benefits by waiting until age 70. Delayed retirement credits. Now, your benefit after your full retirement age increases 8% per year you wait after your full retirement age. And I get this question quite often. What about each month? And yes, each month makes a difference as well. That averages out, or that equates to 0.667% per month you wait. And that adds up to the 8% per year. And it is ideal for those with longevity expectations. And the drawback is the obvious one, you must wait until age 70. And then fewer total payments, fewer years to collect these benefits. And again, you want to consider your individual circumstances, such as your health, family, and financial situation. And what's not on this slide is also how you want to live in retirement. That's important, always important. And here, this chart is here. Feel free to take a picture, screenshot, if you will. Full retirement age. So your year of birth, you'll see here on the left, and with the full retirement age for that year of birth on the right. Those born on 1960 or later, the full retirement age is 67. In a chart here for my visual learners, similar to myself, we'll look at how a claiming age can affect your monthly payment amount. So in this example, we'll assume that this individual claimed at that full retirement age, which for them is age 66. Their full payment amount is $1,900 per month in the gray column. Now, if this person had decided to collect payments at age 62, their monthly payment would have been $1,425. But if they had waited until age 70, that monthly payment would be over $2,508. So deciding when to claim is a personal decision, again, that only you can make. You would want to consider, again, health, saving, expenses, and how this decision can also impact your family. Remember, though, that the impact of claiming age isn't just on your own retirement payment. It also affects the survivor payment your family members may receive if they outlive you. Now I have this case study here on the screen. We have two neighbors, Tia and Andre, who are both eligible for Social Security. Now, Tia decided to claim as early as age 62, the earliest possible age she can receive payments, but they come reduced, but she gets to enjoy that immediate income to pursue hobbies and so forth. But by the time she reached age 78, she realized that her lifetime benefits are significantly less if she had waited. And we have Andre, on the other hand. He waited until age 70 to get his benefits. He receives larger payments due to those delayed retirement credits that we just previously discussed. And although he must use his savings in an interim, such as his 401k, IRA, anything else that he has saved, by age 78, he has received higher monthly payments, and his total benefits have surpassed his despite starting later at age 70. So you can really see the difference in these scenarios when it comes to claiming. Popular topic, this is a short section right here, understanding the impact of relocation. Now, Social Security is a federal retirement payment, so it does not change if you move from state to state. Now, I want to clarify, as you see here on the slide, that certain aspects such as like taxation and SSI, that supplemental security income, may vary by state. Now, I will say that there are some states that do tax Social Security, and Georgia is not one. And relocating to a different state should not jeopardize your entitlement to Social Security benefits. And if you're wondering, You can live abroad, you can move to a different country as well and receive your Social Security payment, as long as they have that signed agreement with the United States. And there are quite a bit of most countries have this agreement, but you can find it on SSA.gov. Popular topic, family payments. Now, you may not be able to predict the future. I wish I could. But with Social Security, it can really help protect your family from it. And you probably are wondering who can collect on your record. So when you start receiving Social Security retirement payments, some members of your family also may qualify to receive payments on your record. With certain requirements, children, spouses, ex-spouses, and survivors can receive Social Security payments on your record. And I'm going to dive into each group right now. So the children of retired, deceased, and disabled workers can, in many cases, collect Social Security payments on a parent's earnings record. Social Security incorporates children into its payment structure to help retirees with younger children provide for their families and as a form of insurance when a parent dies or can't work because of a disability. Within your family, each qualified child may receive a monthly payment up to half of your full retirement age payment. And I'll highlight this later in the presentation, but I just want to just state that when your family or dependent spouse, ex-spouse, or anyone else claims on your Social Security, it does not reduce the amount that you receive. It's a different bucket, if you will. Now, to be eligible for your child must meet certain qualifications. So for children to receive payments, they must be unmarried, not at the age 18, or 18 to 19 years old, and a full-time student up to grade 12, or 18 or older and disabled prior to age 22. Now, however, there is a limit to the amount Social Security can pay your family members, children, and others. The total amount depends on your payment amount and the number of family members who also qualify on your record. The total varies, but generally the total amount your family can receive is about 150% to 180% of your full retirement age payment. Popular topic, spousal payments. Now, if you do not have enough Social Security credits to get payments on your own work record, or your own retirement payment is too small, you may be eligible to receive payments as a spouse. It is important to note that if both you and your spouse are eligible for Social Security payments on your own records, Social Security will pay you whichever amount is higher, but not both. You cannot double dip. And eligible spouses can generally receive 50% of the eligible workers' full retirement age payment amount. Now, even if the working spouse collects early, the spousal payment will be a portion of the worker's full retirement age payment. And if you are still married, you can only file a spousal payment once the working spouse has filed for their own payment. You must be married for at least 1 year, age 62 or older, or you can claim at any age if you are caring for a child under 16 or a child with a disability who is entitled to payments on your spouse's record. And can't talk about spouse without talking ex-spouse. And ex-spouses can receive payments on their former spouse's record if they were married at least 10 years. Fun fact, well, I guess it's not a fun fact, but most divorces that end in America, they end at 8 years on average. Get a question quite often, what if we made it to 9 years and 11 months? Social Security is very strict, unfortunately. The 10 years rule is the requirement. And ex-spouses may file at any time beginning at age 62 and do not need to notify their ex-spouse that they have filed, nor will Social Security let the ex-spouse know either. And eligible ex-spouses can generally receive 50% of the eligible worker's full retirement age payment amount. Even if the former spouse collects early, the ex-spouse's payment will still be a portion of the former spouse's full retirement age payment. Ex-spousal payments do not affect the ex-spouse's payment amount, nor payment amount of a new spouse should they have remarried. And you're eligible to receive these payments on the ex-spouse's record if your ex-spouse receives his or her own Social Security payments, or is at least age 62 and you have been divorced at least 2 years. You yourself are at least 62 and you have not remarried. And it is important to note that if both you and your ex-spouse are eligible for Social Security payments on your own records, Social Security will pay you whichever amount is higher, but not both. Now, next is survivor payments, different than spousal payments. In the event of a spouse's death, a survivor can collect up to 100% of the payment the deceased was receiving or would have received in the future. This will include any delayed retirement credits, as we previously discussed, that the deceased earned. And however, it will also include a reduction if the deceased spouse claimed early. And survivor payments can be claimed as early as age 62, 50 if disabled, but they will be reduced. They can also be claimed at any age if the survivor is caring for an entitled child. Dependent parents may also be able to collect if the deceased parents can show that they have relied on their child for at least half of their support. And ex-spouses may also be eligible if the former spouse was at least 60 or 50 to 59 if disabled, and they were married at least 10 years and have not remarried unless they remarried after 60. And I'll go over that a little bit in the next slide. But survivor payments are only reduced based on when the survivor payment itself is claimed. So it will be based off of when you will claim the survivor payment based off of your full retirement age. In many situations, a surviving spouse can continue to collect on their own record to allow the survivor payment grow until they reach full retirement age. So that is a strategy. And the survivor is still subject to the earnings limit if they haven't yet reached full retirement age and continue to work. Now, when we're talking about how remarrying impacts your survivor payments, now, if you remarry before the age of 60 or 50 if disabled, then you can't receive survivor payments while you are married. But if you remarry after the age of 60 or 50 if disabled, then you can continue to qualify for payments on your deceased spouse's record. However, if your current or new spouse is a Social Security beneficiary, you may want to apply for spousal payments on his or her record. If that amount is more than your widow's or widower's payment, you will receive a combination of these payments that equals a higher amount. And there are several ways you can apply for Social Security. With any of these options, you can apply up to 4 months prior to when you want to begin receiving your payment. And you can apply online by creating a My Social Security account, which is used for several things, including reviewing your earnings record, getting estimates of your payments at various ages, estimating disability payments, and more. And once eligible to apply, you can do so via your My Social Security account, and you can go on login.gov. Also, can apply for payments online at ssa.gov. You can call the 1-800 number you see here on the slide, that's 772-1213, or you can reach out to your closest Social Security field office, and you can find that by visiting ssa.gov/locator. And the big topic, work duration and eligibility. And as was highlighted before I began, I will talk about the Social Security Fairness Act. Now, give me a moment. Let me get a sip of water. I'm talking to myself. Okay. The 2025 Social Security Fairness Act repeals 2 provisions. The windfall elimination provision, also known as WEP, and the government pension offset, also known as GPO. These provisions previously reduced Social Security payments for individuals who also receive pensions from jobs not covered by Social Security, such as teachers, firefighters, and police officers. Now, this new law impacts approximately 3 million current retirees, that's spouses, ex-spouses, and surviving spouses. So if you worked in a public sector job and received a pension, you are likely affected by this change. Now, this law is retroactive to January 1st, 2024, and SSA says that they have completed processing the benefit adjustments under the Fairness Act. This highlights the importance of having a My SSA account and having your information as up to date as possible. And again, to set that up, you can go into login.gov. I'm pretty sure I have some questions towards the end of this, but I want to get into what you want to keep in mind when estimating the amount you'll receive from Social Security. And the biggest thing you want to keep in mind is that cost of living adjustment, or COLA, COLA. Each year, the amount you receive from Social Security will be adjusted to account for inflation for the most part. So in 2026, the cost of living adjustment is 2.8%. And what that equates to, it works out to, is really $50 a month in a raise for your average Social Security payment. And additionally, it's important to consider that currently there's a wage cap on tax earnings. So in 2026, that means that workers only pay FICA taxes on the first $184,500 of their income. And if you happen to have more than one job, your employers are required to withhold FICA taxes. So you'll have to request a refund of any taxes paid on income above this wage cap when you file your taxes. And before you claim your Social Security payments, before your full retirement age, you should know that if you claim early and continue to work, you may be subject to what's known as the Social Security's earnings limit. So in that scenario, your payments will be reduced by $1 for every $2 you earn above the 2026 limit you see here of $24,480. Now, it increases the months prior to reaching your full retirement age. So the year, those months leading into when you turn 66 or 67. And your payments are reduced by $1 for every $3 you earn above that limit. And note that these limits adjust with inflation yearly. So for that $1 and $3, $1 deducted for every $3 earned above the limit, for 2026, that is $65,160. Now, however, if you claim your Social Security retirement payment before your full retirement age and continue to work, some of the payment reduction will be returned to you in the form of a higher monthly payment after you reach your full retirement age, being 66 or 67. And once you reach your full retirement age, this limit no longer applies, and that means that you can continue to work after your full retirement age and make as much as you want without any reduction and still receive your Social Security check. And I want to just talk about taxes on Social Security payments. Now, taxable up to 85%, depending on your combined income specifically. So individual filers, 25,000 to 34,000, up to 50% of your benefits may be taxed. And if your combined income goes over the 34, up to 85% of your benefits may be taxed. A little bit different for joint filers, 32 to 44. You go up to 50% of your benefits are taxed. And if you're above that 44,000 amount, up to 85% of benefits may be taxed. Now, you do have the option to have federal taxes withheld from your payments to avoid owing taxes later. And you can receive that from the IRS.gov website, the voluntary tax withholding form. Again, Georgia is not one of the states that tax. And now these thresholds have not changed since 1984. I just want to highlight. So the inflation pushes more retirees into taxable territory each year. Now, quick slide on the senior tax credit. Would like to also highlight I'm not a tax professional. Just want to just give you this important information. Now, eligibility benefits for this, a 65 or older, or retired, or on permanent taxable disability. Income limits do apply. So full benefit if less than 75,000 or equal to, or 150,000 if married. And it does phase out completely if you go above 175,000 as single, or the 250,000 as married. That credit amount is 3,750 to 7,500, non-refundable. This new deduction for 2025 to 2028, based off of the OBBA, which is that one big bill, extra 6,000 per person or 12,000 per couple under that. And I'm gonna go into payment limits. Now, understanding maximum Social Security payment. Some people ask, what is the maximum someone can receive? Which I thought was very important to include this slide for today. And the maximum Social Security retirement payment does vary based on the age you retire, which we went over in the beginning, the 62 to 67. And it does depend on the average income you earned over 35 years, the cost of living adjustment, and other factors. So retirement age versus your maximum payment. So if you retire at age 62 in 2026, maximum benefit is $3,082. At your full retirement age, again, 66 or 67, the maximum payment will be $4,152. And if you opt for retirement at age 70, and that should say 2026, in 2026, you would yield a maximum benefit of $5,521. And how can you estimate that? Now, the exact amount of your monthly payment is based on what you've earned during your lifetime again, and the Social Security Administration will look at your highest 35 years of earning. So it is your highest. So if one of your years you worked part-time or something like that, it will not knock off one of your highest years. Or if you stop working, let's say at 62 and then claim at 70, those years in between won't affect it either. It's still your highest 35 years since you began working and paying FICA taxes specifically. Now, if you would like to estimate your payment, there's a few ways you can do it. You can open up a My SSA account again at login.gov. You can go on ssa.gov online and print out to complete the Form 7004 and send that over to the Social Security Administration. You can call the 1-800 number, 772-1213. And once you turn 60, and assuming that you have not claimed Social Security payments and you haven't set up a My SSA account, you automatically will receive an annual Social Security statement in the mail, and it will come 3 months, 3 months before your birthday each year. The popular topic, the future of Social Security and protecting and strengthening it. Now, Congress has several options to address the program's long-term physical challenges. For example, here are 5 potential solutions to make sure that Social Security can pay out 100% of earned payments for everyone who is eligible for generations to come. You can learn more with these free resources, that being the Council for Economic Education and also the American Academy of Actuaries. Now, I know I've been doing a lot of talking. I want to just go over some commonly asked questions. I would like to look at the chat if I can see if I can bring it up here. Now, how long do you have to work to qualify for Social Security? I want to just make sure that I did what I had to do to make sure everyone got some good information. And I'm going to check the chat now. See, somebody said number 3. Okay, another 3 from Patrick Crabtree. Thank you, Patrick. Okay. Now, there we go. Social Security does use a system of credits called quarters, and you need to earn 40 quarters, which is 10 credits to qualify for Social Security retirement benefits. So if you were thinking 3, you are correct. You can earn up to 4 credits. Oh, let me get that off the screen. You can earn up to 4 credits per year. So it takes 10 years to earn 40 quarters. Now I'll go over some true or false. You don't have to worry about answering these because I will answer them for you. Is Social Security going broke? Now that is false. Now Social Security will not run out of money as long as workers and employers continue to pay payroll taxes. It is a pay-as-you-go system. So I pay, you pay, we all pay. Revenue coming in from payroll taxes largely covers the payments going out. But Social Security does face long-term funding changes. So at about 10 years, 2025, going on 2026. So that is now, I believe, 7 years. When the reserves are used up, Social Security will only have sufficient money coming in to pay about 80% of earned benefits. So instead of $1,000, be $800. Next question, members of Congress do not have to pay into Social Security. That is also false. All members of Congress, the president, the vice president, and most political appointees have been fully covered under Social Security programs starting in January of 1984. So all members of Congress, no matter how long they've been in office, have been paying those FICA taxes since 1984. And I'll try my best to keep Social Security fun. Still have the chat here in front of me. So how many payments have Social Security missed? Does anyone happen to want to just take a jab at that to see what's that, 536,981? How about B for 0, C for 5 million? See if there's any in the chat here. Thank you, Patricia, for B. See, Tamisha for B. Thank you for that. Now, if you were thinking B, you are correct. It is 0 payment. Social Security is the one protected, inflation-protected retirement payment that you can receive. You might see some financial advisors talking about when you're doing your research of using your savings or doing what you can to push your claiming out as far as possible to get that guaranteed income. But 0 payments since it was created. And what list does Social Security Administration release each year? This is probably one of my favorite questions because I get so many different answers. If anybody wants to take a swing at that one, of what Social Security Administration releases each year. Give it a few seconds. Okay, got a couple of last choices for letter D, top baby names, and you are correct. Social Security does release the top baby names each year. Since they are the ones that supply the Social Security number, they do know the most popular names. So you can actually go on SSA.gov and look at the year you were born to see if your name made the list. I did have a colleague that said they still check the list every year just to see if their name is still ranking at the top. Their name was Jessica, so they just wanted to just see if it keeps making the list. Now, as far as resources, I am the sole editor of the Social Security for Dummies book. It is a trusted voice from a trusted voice and a thought leader here at AARP. You can reach and purchase this book on any major bookstore, Amazon, or wherever you shop for your reading materials. It is there. Also coming soon, I do have a book coming, the top 100 in question and answers on Social Security. It's due to release in January. It's a shorter read, easier to digest. Each question has 1 to 2 paragraphs for each answer. So just definitely check that out. Again, that is the top 100 question and answers for Social Security. AARP also has a Your Question and Answer tool. So you can go to answers.aarp.org. You do not have to be a member. It is free. You can go here, you can type in your question, and it will give you, it's basically access to our frequently asked question bank. So if you have the question, there's a chance that 1,000 of others have the same question. So if you go here, you can use this tool for free to see if you can find an answer to your question. Also, if you cannot find an answer to your question through this tool, at that bottom, you will see Ask an Expert. That will let you send an email to me directly or my colleague, and we'll be able to respond to you via email, and you can reply with a follow-up question as well. So definitely check out that. And here are some more resources. You can check out the educational website, the aarp.org/social security. Again, that Your Questions Answered tool. You can estimate your payments for free with our Social Security calculator. And if you want to learn more about protecting Social Security, you can look at aarp.org/advocacy. Now, I want to thank everyone for listening. I know I was sitting here talking for a while to this screen, but I am available to take any questions if you do have them. Now,
I have a question.
Yes.
It's about collecting ex-spouse's Social Security. What if the ex-spouse passed before they were able to collect Social Security? Can the ex-spouse still file for their Social Security?
That is a great question. So for survivor benefits, if anyone is having a similar question, Those survivor payments are for if you were claiming and they passed away, or what they would have possibly received. So if they, say, for example, passed at 68 or 69 and didn't claim yet, their surviving spouse will still be eligible to receive the payments that they would have received.
This is an ex-spouse. We were married.
Ex-spouse.
Yeah, we were married over 10 years. They were married over 10 years, but then he passed after the divorce, but they passed before retirement age. He actually passed at 47.
Yes. So as an ex-spouse, you are able to also claim those survivor payments as well, as long as you was married for at least 10 years.
Yes, we were. Okay.
Yep.
Thank you so very much.
You're welcome. Next, anyone else? Feel free to come off of mute. I see Patrick with his hand up.
I do have a question, but first of all, I want to thank you for a wonderful, wonderful presentation. It's very thorough. Often we hear that the government says we got to cut Social Security because it's eating into our budget. I think I know the answer to this. Is not part of the budget. They only place it in because it is a separate entity away from the budget. It is its own entity. All they do is make the payments for the organization, for our retirement system. Am I correct?
You are correct.
So when we hear these politicians say it's eating into our budget, they're lying to us.
Well, I won't touch that part. I won't get too political, but it is a pay-as-you-go system. So as you stated, I pay, you pay, we pay these FICA taxes. So, and what I will say, like as a fun fact, is that when back in the 1950s, there was 12.4 workers per retiree. In 2034, instead of 12, it'll be 2.3 workers per retiree. So a big difference. So that is the solvency issue that Social Security is facing. And I hope that answers you. You're welcome.
You did.
Any other questions? Anybody want to drop them in the chat? Come off of mute.
Cynthia has her hand raised.
Okay. Hey, Cynthia. Yeah. You're cutting in and out a little bit. Might be a bad connection, possibly.
Who would be able to, if they have ex-spouses, multiple ex-spouses, how does that determine which spouse get the survivor benefits? Is it who get there first or who apply first? How does that work?
Yeah, and that's a good question. So it is a certain bucket. So let's just say 4,000 or 5,000, something like that. So if there's multiple ex-spouses, every ex-spouse will get a portion to what they're entitled to on that work record. If that answers your question. I'm trying to keep it as simple as possible without going into too many details, but it isn't who goes first. Everyone will basically be entitled to receive a payment as long as they were married to this individual that has the work record for at least 10 years. I hope that answers your question.
Yes, thank you.
Jamie, I have a question.
Yes.
When you do receive survivor benefits, what percentage of your spouse's Social Security payment do you receive?
Sorry, I was answering a question in the chat from Tamisha. Sorry. Can you repeat that for me, Tony?
When you do receive survivor benefits, what percentage of your spouse's payments do you receive?
And that's a great question. So you receive up to 100% of what the deceased would have received. So it's 100% was receiving or would have received in the future. And it depends on the age at which the individual would claim the survivor benefit. It's going to be based off of that age and if you are at your full retirement age or not. And what a good strategy that a lot of people usually take advantage of with survivor payments is that they will claim, they will claim their own and use that and then claim the survivor payment at, let's say, 70 if the deceased individual had a higher income over the course of their career.
Thank you.
Yeah, problem. Any other questions for me?
Yes. Is
Yes.
there a penalty for someone who's 70 years old and who has waited to collect their Social Security at age 70 and they're still working? Is there a penalty for them? Is there a tax penalty or?
Yeah, so great question. So there's no penalty. I would like to highlight, just in case if anybody else was wondering, once you reach age 70, waiting past that, let's say 70 in 1 month, that extra month after 70 makes no difference. So don't leave money on the table, if you will. You can claim at 70. That's the max age at which you can claim. No penalty for claiming at 70 because you're past your full retirement age, which would be 66 or 67. And once you reach your full retirement age, you can work as much as you want without your Social Security benefits being reduced. Now, you might still be on the hook for taxes. We still all have to pay taxes. So you might have to pay taxes on your Social Security benefit, but it will not be reduced based off of when you claimed.
Okay, thank you.
You're welcome.
I have
Any
another
other?
question.
Yeah.
Yeah. If you do continue working past age 70, I want to clarify this in my mind. You can still apply for your Social Security benefits. Is that correct?
Yeah, so you can file for your Social Security benefits as retirement specifically at any as early as age 62. The one thing you want to look out for is if you are still working or not after you claim. But again, if you claim your Social Security, or you reach your full retirement age, 66 or 67, you can work as much as you want, and you will not be penalized by working and receiving your Social Security payment. You can do both. And I see someone asked in the chat, if I'm full retirement age, can I get FICA taxes back? Unfortunately, you cannot. So it's a pay-as-you-go system, as me and Patrick previously discussed. So I'm paying now for those that are currently receiving retirement. If you are making over a certain threshold, and you have that additional income over that taxable amount, then Social Security views that you make too much. I'm doing air quotes. You make too much, so they want you to give back into the system as well to keep it strong for current and future generations. So we all pay. It's like a social insurance for all of us in retirement. You're welcome. Any other questions? Now, I want to just state, and I did say interesting, since there's no questions, I'll give an interesting answer to a question I received last month. Someone asked, if I was married 3 times and all marriages lasted 10 years, what happens? One of the most interesting questions I've received. For that individual in that situation would have options, a lot of options on how to get their biggest Social Security payment. So they will be able to file for all those on the ex-spouse, if they're over 60, their current spouse, and their own work record. And Social Security will give them the highest of the highest payment with that of those different options. If anybody, just a fun fact of a question that I received last month. Any other questions that might have came up? Oh, not seeing any questions pop up, Tony. Oh, is someone talking?
Yes, me. If does a person have to be married 10 years in order to get a deceased spouse's Social Security?
So let me just make sure I'm following the question right. So the spouse passed away.
Yes.
But that individual in this situation is divorced as well from that person that predeceased them.
No, they died. They were recently married. They were over 60,
Okay.
and the spouse passed away. Is that person eligible for Social Security?
Okay, I'm gonna
Also,
just okay. I'm gonna give you both. I guess where I'm following at. Just I hope this answers your question. So for spousal, if you were currently married and they passed away, you are eligible to receive on that spouse. Now, if you happen to divorce this individual and then remarry after 60, you are able to collect on that previous spouse, and you might want to also consider claiming on your current spouse if they're receiving as well. Did that answer your question?
yes, but I
Okay.
want to. Okay, the person seems to think that they cannot receive any Social Security benefit from their deceased spouse. They were married about 2 years, so
Ah,
they're
that part. Yes, yes. So they're on the right track. So they had to at least be married for 10 years.
years.
Yep,
Okay,
10 years. Yep.
okay, thank you.
You're welcome. Thanks, Pat, for the kudos. I appreciate it. Any other questions?
I have a question. So the 10 years only applies if they were divorced.
Correct. That is for divorce specifically.
Okay, thank you.
You're welcome. You're welcome. And since I got so many survivor questions, I just want to just add some extra knowledge, leave a little thought, just in case you might have not been thinking about it. So if you're already receiving spousal payments, Social Security will switch you to survivor payments automatically upon the spouse's death. Just if anybody would have that question now or in the future. And if it's not automatically converted, you can apply by calling Social Security or visiting your Social Security field office and supplying that certificate of death, the same that the funeral home would have. It is on a funeral director to give this information to Social Security Administration, but it's always a great plan to just make sure you do it as well, just to make sure everything is done correctly. And if there are any military or serving or veterans on the call, no length of marriage requirement if the death was accidental or occurred in the line of U.S. military duty. This is for survivor payments. And again, remarrying before age 60 or 50 if disabled does affect your eligibility for survivor payments. But if you get married at 60 or after 60 or 50 if disabled, it will not affect your survivor payment. Any other questions?
So I do have one other question.
Yes.
If the spouse was receiving disability benefits, but the surviving spouse is under the retirement age, are they still eligible for spousal payments?
Now, give me that scenario again. So I'm following. So someone's receiving disability.
The spouse was receiving disability payments, passed
Yep.
away. The surviving spouse is under their retirement age. Are
Okay.
they eligible for spousal benefits?
So spousal benefits specifically are when both individuals are living. Survivor
Mhm.
benefits is for just the situation at hand for surviving.
So yes. So the question I guess would be related to survivor benefits. Are they eligible for survivor benefits even though they have not reached retirement age?
So you can apply for survivor benefits as early as age 60, or if that spouse was disabled, they can apply as early as 50 years old.
Okay.
Yeah, but it will come with a reduction because it's based off of when that surviving spouse claims. So if you claim at 60 as early as possible, you'll see a permanent reduction. So you could claim at your full retirement age. So what some individuals do is what they'll do is they'll claim their own Social Security benefit at 62 as early as possible, and they'll wait until they reach age 70 and then switch to survivor benefits, which is sometimes higher than their own benefit.
Okay, thank you.
You're welcome.
Okay, Jamie, I have another question based on what
Yes.
you just said. So you cannot receive survival benefits and your own benefits at the same time?
Yep, you cannot receive any double dipping of benefits in anything with Social Security. You will get what you're entitled to and what is the highest amount you're entitled to only.
Okay. Okay. Thank you. I wasn't
You're
clear
welcome.
on that. I appreciate that.
Yeah. And going back to the question about disability as well, if you're on disability or Social Security disability, SSDI, when you reach your full retirement age, Social Security will automatically switch you to retirement, or some individuals refer to it as normal Social Security, and your payment will most likely stay the same. I know that's always a question too. Like, will my disability, when I switch, will my payment increase? It usually will stay the same because Social Security bases your Social Security disability amount based off of what your amount would have been if you were at your full retirement age. So keep that in mind if you do have that question or friends have that question. Anything else for me?
Well, Jamie, this has been wonderful. It's been so informative. We did not
Yes.
know we had the sole editor of Social Security for Dummies
Yes,
with us
yes.
today. Thank you so very much.
You are welcome.
We can't wait for you to join us again in January.
Yes.
This has been amazing. Thank you so very much.
You're welcome.
All right. We are going to hear next from Mike Zarum from TRS, but he has not joined us yet. So what we're going to do is we're going to move Medicare up on the schedule, and we are going to watch a short video from Medicare.gov on Medicare, and then we're going to on the parts of Medicare, and then we're going to learn a little bit about working past 65 in Medicare. One of the things that you need to understand is that Medicare and Medicaid are different. Medicare is for people who have working income, and let me see, I'm trying to share my screen here. And so we're going to learn about the parts of Medicare, and then we will talk a little bit about working past 65. So I hope everyone can see my screen.
When you're first getting started with Medicare, there can be a lot to learn and consider, and it might seem overwhelming. Let's start at the beginning with the ABCs and D of Medicare. Medicare includes parts that are the building blocks of your health and drug coverage: Part A, Part B, and Part D. And there's also Medicare Advantage, sometimes known as Medicare Part C. Let's start with Medicare Part A. Medicare Part A is sometimes called hospital insurance. It covers hospital care, like inpatient care at a hospital, skilled nursing facility care, hospice care, and some home health care. Usually, you don't need to pay a monthly premium for Part A. Medicare Part B, or medical insurance, covers services like certain doctor visits, outpatient care, medical equipment like wheelchairs, and preventive services like flu shots. With Part B, you'll pay a premium every month. In many cases, if you don't sign up when you're first eligible, you'll have to pay a late enrollment penalty. which is added to the monthly premium cost for as long as you have Part B. That can add up, so it's important to pay attention to your deadlines. Medicare Part A and Part B are both under what's called Original Medicare. If you want drug coverage too, then you can join a separate Medicare Part D plan. Medicare Part D coverage is provided by private companies that you can choose from. For a Medicare Part D plan, you'll pay a monthly premium that depends on the plan. Remember to consider your plan options when you're first eligible to avoid late enrollment penalties. And finally, there's Medicare Advantage, also known as Medicare Part C. Medicare Advantage plans are another way to get your Medicare Part A and Part B coverage. These are Medicare-approved plans offered by private companies that bundle your Part A and Part B coverage, and usually include Part D drug coverage too. Most plans include extra benefits like vision, hearing, dental, and more. Ready to learn more? Visit Medicare.gov or review the Medicare and You handbook. You can also watch the other Get Started with Medicare videos at Medicare.gov. This product was produced at U.S. taxpayer expense.
Okay, that's a little bit about Medicare. We'll talk more about it later because now Mike Zerum from TRS, our rock star, is in the room. So I'm going to make Mike a co-host so that he can share his screen. Mike, we are so happy to have you as always. This is the part that we really, really, really live for. So I am going to turn it over to you.
It just changed all my equipment. I'm lucky to be here right now, and I'm not sure how to exactly. We'll put see here. Okay. Yeah.
Sure.
Right. Seeing that? Yep.
Not yet. We don't see your screen yet. We see you, but not your screen. There we go. Well, let's see. I see me. Let's see. What I see is me. There we go.
Okay, you seeing that now?
Yes, we've got your presentation.
Okay. All right, sorry about that, but we're on time, so that's good.
Yes.
Nobody realizes it more than you, but as teachers, you work hard and deserve a great benefits package. And when you put together what you're going to get from TRS and continuing your state health benefit plan coverage, it really is a marvelous benefits package. I talked to a lot of financial advisors over the state, and they all wish they were in TRS themselves. So it's hard to get a better endorsement than that. I think conceptually, it's real important to understand that your benefit is not tied to the ups and downs of the stock market. It can go up or down, and it doesn't impact what you're going to get from us. Also, it doesn't matter how much money you've put in to TRS, because the amount you get from us is a function of how long you've worked, high salary. And we're going to look at that when we see the formula. So essentially, the longer you work, the higher your salary, the more you're going to get. You don't have to worry about the ups and downs of it. You don't have to worry about running out of money. It's a guaranteed lifetime benefit. That's probably the biggest fear a lot of retirees have, is that they're gonna live beyond their income, and that's not an issue with TRS. We have over 4,000 retirees who are over age 90 and 100 retirees over 100. A lot of retirees who've been collecting years or longer than they were working. It's also a guaranteed lifetime benefit for any covered survivors. So you can pick an option that leaves a monthly benefit to, say children or a spouse or whomever you designate. And their benefit, once you pass away, assuming it's first, they keep that benefit for life as well. There are different directions you can go and different decisions to make. And we're going to look at all the plans you have to pick from. We're going to touch on cost of living adjustments and planning your monthly budget accordingly. We'll look at partial lump sum option plans and what that means. You have to decide whether or not you want one of those or not. But probably the biggest question you have, or most common one, is, how much am I going to need to maintain my standard of living in retirement? And the answer to that is painting broad brushstroke, according to the experts. You want to replace at least 80% of your pre-retirement income. So when you add TRS, your 403B or 457, plus Social Security you may be getting, and any other savings, you want to at least cross that 80% threshold. Now, everyone's different. You may have more expensive goals in retirement, and you may need more of what we call a higher replacement ratio, a ratio of the income you have in retirement versus while you were working. You may, if you're like most people, you want certified licensed financial advisors to help you make those decisions in terms of what you're going to need. No one at TRS is going to be able to do that for you, but we can get you, started talking in general terms. Here's that formula that I mentioned to you earlier. We're going to take your years of creditable service, and that's your day-to-day membership service, your unused sick leave credit, and purchased services. And you can have partial years. We're going to dump all that in one bucket. We're going to take that total and multiply it by 2%. And then we're going to multiply it by your high average salary, which is your highest consecutive 24 months of pay, wherever they happen to be. Quite often they're your last 24 months, but it's not required. It can be right in the middle, just wherever the highest 24 rolling average happens to be. And we're going to multiply all that together, and that is your starting benefit under the maximum plan. That's the most you can get from TRS. Most of you could probably figure out your maximum benefit. Say you had 30 years of service times 2%, you're going to get 60% of your high salary, and that'll be your starting benefit once you retire. All the other plans that we're going to talk about are going to be some kind of actuarial deduction from your maximum benefit. So your age and the age of your beneficiaries will have an impact on what you would receive or the other benefits. Sure, benefit. Yes.
We're having a little trouble with your sound. It's repeating and skipping. So I just wanted to
I'm
make
not
you
sure.
aware of that. I'm not sure what's causing it.
Because I'm not, unless I'm, let's see.
I know you have on your headset. Is your mic open on your computer too?
Well, let me pull out the microphone.
Can you hear me now?
Say something else.
Okay.
No, we heard you better before. So maybe you better use your headset. The picture is fine.
Yeah. Okay. Sure what's causing that.
It actually would be helpful if the picture was full screen as well.
There we go.
Because on my end it's showing full screen.
Right. Well, we see it now full screen. Thank you.
Okay. All right. All your other benefits will be an actuarial reduction from your maximum benefit. Now, once you start getting a check from us, certain deductions won't occur that you're used to now. For example, there's no TRS deduction from your TRS check, and that saves you 6% right there. There's no 403B deduction that many of you are using. There's no, and the biggest one is there's no payroll tax. So there's no Social Security, Medicare, and all the other little components that add up to 7.5%. So when you start adding all that up, your take-home pay in retirement starts to look a lot closer to your take-home pay while you were working. Now, there is one deduction I think you probably all want to see, and that's for your state health benefit plan coverage. And whatever you had prior to retirement by default is carried in retirement. And then concurrent with the open enrollment for active teachers, you have change period where you can change between or among the options, like between Anthem, United Healthcare, but it's not a true open enrollment. If you get out or you join one of those private sector Medicare plans, like you hear Joe Namath or Jimmy J.J. Walker talk on commercials, about retirees jump on board thinking it was a great thing, and then they lost their state health benefit plan coverage. So, once you're out, you can't get back in. So, if you're pre-65, stay in the active teacher plan, and then once you turn 65 in retirement, you'll transition to a Medicare Advantage plan where you have what they call Medicare Part C, where Medicare is incorporated along with your United or Anthem, whatever you have as hybrid plan. It has full drug coverage. Our retirees like, and then people don't realize this, but the TRS has nothing to do with your state health benefit plan coverage. That is handled by the Department of Community Health. And, they have an 800 number retiree line. If you have any questions regarding caring coverage, you can also ask your benefit coordinator at your central office with your Board of Education if you have any questions. Our part in this is simply to get instruction, the health plan about your premium deduction. We'll pull the money out, check, and we send it to the state health benefit plan. So that's how payments get made. But if you have any claim issues or eligibility issues, they need to be addressed to the Department of Community Health. That's the umbrella agency that has within it the state benefit plan. Okay, so when you retire, there's two thresholds for a normal retirement, and that would be 30 years of service at any age. Sure, you have years who earlier on in your career were talking about getting that's how old you go. We have people who are 47, 40, 48, a lot of 50, because they're young, and they might have more on, but it helped them get away. Now you don't have to retire.
I'm hearing you again.
Okay, let's see.
There's nothing wrong with the picture. It's just the microphone is skipping. Maybe if you unplug it and plug it back in again.
Can you hear me now?
Yes.
Okay, good. The other threshold would be for now based on you're gonna get work.
We're still having sound issues. Yeah. And maybe it's just me. Is anybody else hearing Mike break in and out?
Yes, ma'am, it is.
Okay.
Well,
but just keep plugging away, and we'll make the best of it. Don't stop.
Yeah.
So you can go back to your full screen presentation. Yeah, that's good.
Okay. So you can take, I guess I'll talk slower. You can take an early retirement with a penalty if you have 25 but less than 30 years and you're under age 60. It's a very significant penalty. We're going to apply 2 penalties, and we'll apply the penalty that yields you the largest benefit. But essentially, for every year you have under 30, or for every year you're under 60, you get 7% less of whatever your normal benefit would have been. Plus, you don't get a cost of living adjustment or COLA until you would have had a normal retirement. Since it is such a big penalty, not many people take it. So here are the different retirement plans that you have to choose from. I think the easiest thing to do when you're trying to decide is to break up the available plans into 2 groups. 1 to 1 left. provide you the high benefit, but no survivor benefit. And conversely, options 2 through 4 leave varying sums of money to one or more beneficiaries. So if you know you don't have anyone who needs money should you pass away first, you may want to focus on the maximum plan or option 1, because that'll yield a higher monthly benefit for you. If you know you want to leave a monthly benefit to a spouse or children or any other beneficiary, you'd be looking at options 2 through 4. And we're going to look at each of these in more depth shortly. I think conceptually it helps to understand that your TRS account is broken into 2 buckets of money. One I'll call your bucket, where your contributions and interests go that came out of your paycheck. And then we have the TRS bucket, where all the employer contributions go and where all the return on investment money goes to pay your lifetime benefit and that of any covered survivors once your bucket of money has run out. Your bucket of money pays the very first benefit checks for the first 2 to 3 years. And then the other bucket will kick in at that point and pay a lifetime benefit for you and any covered survivors. We never keep any of the money that went into your bucket. That's always going to go back to you or a beneficiary. And we'll learn more about that when we conclude with the beneficiary section. So Plan A maximum. This is the formula that we looked at earlier today, where you take your years of creditable service times the 2% times your high average salary. That's your maximum. And if you take the maximum, which 2/3 of our members do, and you pass away before your bucket of money is used up, we're going to pay in a lump sum, a one-time lump sum, what's in your bucket to your designated beneficiary. Now, hopefully you'll live more than that 2 to 3 years, and when you pay, there won't be anything left in your bucket to leave anyone. Remember, there's no lifetime monthly benefit under either of these 2 plans. But you do get the most you can from TRS. For a slight reduction from your maximum, you can take option 1. And what that does is it extends the life of your bucket of money from that 2 years to the 10 to 14 years, which means if you pass away before the 10 to 14 year period is up, we will refund in a lump sum whatever left to your designated beneficiary. So, there's a little added protection there for a lump sum distribution. But remember, again, there's no lifetime monthly benefit. Now, these other 2, the options 2 through 4 kind of work like a ride on a seesaw or teeter-totter. I'm from the Midwest. I'm not sure what you call them here in the South. But the more you leave others, the less you're going to get. And the more you decide you want for yourself, the less beneficiaries would get. And you're going to decide where on this teeter-totter ride you want to get off. There's no right or wrong answer. Actuarially, these plans all have the same value, which means it doesn't matter to us which one you pick, because based on actuarial statistics, they all cost us the same amount of money. The lifetime payout's the same under all of them based on mortality. So if you're going to go this route, you just pick what's best for you and your family. With option 2, it's very rich for your beneficiary. Whatever you are getting when you pass away is the starting benefit for your designated beneficiary. So if you take option 2 and you pass away making $4,000 a month, your beneficiary would get that same $4,000 a month. Now, it's expensive to leave that kind of benefit. Your reduction is typically, I'd say, 10 to 25% less than your maximum benefit. But you'll see what that reduction is once you get a benefit estimate. Option 3 leaves your beneficiary 1/2 of what you were getting when you pass away. So in our example, if you were leaving 4,000, or if you were getting 4,000 a month when you pass away, your beneficiary would get 1/2 or $2,000 per month. And that may be enough for them to be just fine. In which case, while you're both living, you're going to get more money from TRS. The reduction is maybe 5 to 15% for option 3. Now, option 2 and 3 have a cousin option or sister version called the pop-up, where you can, if provided you have one primary beneficiary, under all the other options, you can have as many beneficiaries as you want. But with a pop-up, you can only have one. And if that sole primary beneficiary dies first, your benefit up to the maximum plan of benefits. It's usually about a $200 to $400 increase in your monthly benefit if that beneficiary dies first. So if it makes sense to get more money when someone passes away, maybe they had an income flow because they were working, for example, you might want to look at the pop-up. It is not expensive, relatively speaking. It might reduce your option 2 or 3 benefit, $75 to $125. That's quite often what I see to add the pop-up. But remember, you can only have the one beneficiary. Now, option 4 lets you, within certain IRS and administrative limits, designate a fixed dollar amount, which would grow with COLAs, or a percentage of your benefit. So if the other options didn't work well for you and your family, you could designate $1,000 a month, or 33%, or 75%, whatever, within limits, whatever you want. So you can fine tune that teeter-totter ride to leave them what they're going to need, while at the same time maximizing what you're both going to get while you're both living. Okay. You are now all experts on SHB or TRS options. So we're going to do a little quiz. Hopefully you can hear me well enough. And you're going to tell me I'm going to tell you actually what option might be best after giving you a second to think about it. And you might want to use this same kind of logic or decision-making process when you're making the decision. So you got Mary, who has no dependents, and no one depends on her income. So if you were Mary, what option might you reasonably take? And the idea here is that Mary would take the maximum plan, because If Mary dies first, no one will have a financial hardship. So why shouldn't Mary enjoy as much money as she can get? Now, in scenario 2, we have loving Sue, who has a spouse that doesn't have any savings, and that spouse won't be getting a pension or Social Security. And despite his many attempts, he has yet to win the lotto. And because Sue is a loving spouse, what option do you think Sue might reasonably select? Well, if you're thinking option 2, that's what we're thinking as well. Because Sue's spouse will have nothing if Sue passes first. So Sue's going to provide as much protection as she can for that spouse and take option 2, which pays out the most. Okay, in scenario 3, we have Tom, who's also married, but that spouse will be getting a pension and Social Security. But when they run the numbers, the spouse is still short $500 a month of meeting her needs if Tom dies first. So if you were Tom trying to make the best choice, what might you reasonably select? Well, the idea here is that Tom would customize the benefit and take option 4 and leave that $500 a month death benefit or survivor benefit to the spouse. So if Tom dies first, the spouse gets that $500 a month and can make ends meet. And at the same time, while Tom and the spouse are both living, they're going to get more money from TRS than they would have, say, in option 2 or 3. So you might want to utilize this kind of thinking. Obviously, everyone's life scenario is more complicated, but this gives you an idea of how you might want to approach making that decision. Okay, once you've decided what option you want, you need to decide yes or no on whether or not you want a partial lump sum option plan, or PLOP for short. It's a lump sum distribution of cash that you get about a month or so after you retire. It's anywhere from 1 month to 36 months of your maximum benefit. About 1 in 10 of our retirees take it. The gross amount before any taxes is $65,000 on average. Now, for that, you take a rather significant reduction in your lifetime monthly benefit. For every $1,000 of PLOP you want, depending on your age, you take a $7 to $10 a month reduction per 1,000. But it might come in handy to maybe pay off some high interest credit card debt. Maybe you want to have a quasi form of life insurance. Maybe you want to help a grandchild through college. Maybe you want seed money for a business. You just may have to make sure that the monthly income that you're left with is going to meet your needs. Now, once you start taking that money, there, as you might expect, there are taxes. If you're under age 55, there could be a penalty tax too. It's not 59.5 in this case, it's 55. But you can defer taxes by having the money placed into your 403B without you touching it. It's called a direct rollover. Or you could put it into an IRA at your local bank, and then you wouldn't pay taxes on it until you started taking it out. But there are minimum distribution rules. At some point, I don't remember, they change it all the time. Maybe at 70 or 72, you'd have to start taking it out if you hadn't already. A fantastic, wonderful, beautiful kind of scarce or rare component of what you get relative to other pensioners is this 1.5% COLA, or cost of living adjustment, every January and July, provided that there's inflation as measured by the Consumer Price Index, or CPI for short. And it's not all that common. In fact, it's pretty rare that we would not have CPI inflation. I've seen it happen once or twice, and some retirees have had to wait a period of time for prices to get back up to what they were at retirement, and then COLAs would resume. That did happen in the Great Recession of 08 or 09. Now, your very first COLA is cycled in. It takes 7 to 12 months depending on your retirement date. But you can see by the last two bullets on the screen that if you're the typical classroom teacher who stops working in May, you'd be a June 1 retirement. You'd only have to wait 7 months to the following January. But let's say you had to work a day in June, maybe a weather day, then you're a July 1 retirement, and you'd have to wait a whole year to get your first COLA. Now, from one COLA to the next, it may not seem like it's a large increase, but it really adds up over time. Once you've been retired 12 years, you're making 50% more than when you started. So I get retirees coming to me all the time saying, you know, Mike, I'm making more in retirement now than I did while I was working. And that's a great feeling. So we're going to look at a benefit example. This person had 30 years of service times the 2% in the formula, which means they're going to get 60% of their $5,800 high salary, which comes out to exactly a $3,500 a month benefit. And they just retired back in June. So this is the top half of what we call a benefit estimate. We recommend you get one when you're 2 years out from retirement. You can get them from us as early as 5 years out. You can go through your TRS online account and set up an appointment to have a counselor talk with you after you'll pick a date and time online, and then we'll share your estimate with you virtually through Microsoft Teams, or we could meet in person with you, at our Atlanta office or Macon office. Or if you want, we can just do it over the phone too. But whatever platform works easiest or best for you, it's available out there. Now, you're going to go online and give us certain assumptions. You're going to tell us when you want to retire. We're going to show you who you've got listed as your beneficiaries. We don't know your unused sick leave credit. A lot of teachers think we have a record of that. We don't actually know what it is until after you've retired and all your former and last employer certifies your unused sick leave. So you're going to have to give us your best guess on your anticipated sick leave service to get an accurate estimate. If you've been to other systems and you're not going back, you can take care of that now. Go ahead, go on to our website, which is www.trsga.com, and you can go to the Forms tab, and download the final unused sick leave certification form, and it's a writable, signable PDF. You fill out your part, you email it to the benefit or payroll person at the central office for the district you worked at previously. They'll fill out their part and email it back to us. And then you're done. You don't have to worry about it when you're retiring. Now, your very last employer, it's easier. We don't need a form from them. We'll email them directly and they email it directly back. Unfortunately, we can't do that with any employers prior to your last one. Okay, so getting back to this estimate, and we do recommend you get one when you're 2 years out. And by the way, I believe it's on the publications tab on the website, there's something called a 24-month checklist. It's a really good document that'll help you get all your ducks in a row. I suggest you all download that and print it. It's the 24-month checklist. All right, so here is the top half of the estimate. It shows you your minimum and maximum plop amounts, when you're planning to retire, how old you'll be. It'll show you your current service, how much more you'll have until you retire, what you'll have at your projected retirement. You're going to plug in your sick leave. Anticipated other service, that might be a service purchase that you haven't made yet, that we'll talk about later. If you want to assume an annual increase, you can plug that in too. If you want to be conservative, you can leave it at 0. So let's go now to the bottom half of the estimate. This shows you how much you're going to get under all the different options. And remember, obviously, your numbers are going to be different based on your age, high salary, and the age or ages of your beneficiaries. But you can see under the max plan, you're getting the most you can per month. It's a very small $10 about reduction for option 1. Option 2, you take about a $225 reduction from your max plan. But if the member dies first, the primary beneficiary gets the same amount. Now in the pop-up, you take about a $23 a month reduction compared to option 2. But if the beneficiary dies first, the member's benefit pops up from the $3,250 to the $3,500. So it's a $250 pop-up. You can see the reduction for option 3 is about what, $117 a month. So you're getting more under option 3 than 2, but primary only gets half, or $1,691, not the $3,383. And that may be enough for them. But while you're both living, you're going to get more per month. The pop-up works the same as option 2. If you want an option 4 or customized benefit estimate, you can ask for it, and you can have multiple estimates if you want to try different numbers. But as a courtesy, we usually throw $500 in, and that only knocked the benefit down $35 a month. So, you get an idea of how cost effective it is. Now, remember I talked about the plop reduction? That's the middle row there. And it shows you, based on the option you select, what your reduction would be per $1,000. So if you wanted a $1,000 plop under Plan A maximum, you would reduce that $3,500 per month by $6.57. Okay. The other thing to point out, as we discussed under the max plan in option 1, if you, the retiree, passes first, your primary is not going to get anything. And that's why you see those zeros there after the primary beneficiary. So that, in a nutshell, is what your estimate's going to look like in general. And remember, you can get these up to 5 years ahead of time. We do recommend that you get an official one from us when you're 2 years out. There is a wonderful tool once you're within 5 years of eligibility through our website. It's called Generate Benefit Estimate Tool. And it's the same software we use. And you can go in there and do different scenarios. You can work benefits estimates backwards. You tell the computer you want to have exactly 30 years. It'll tell you when you can retire based on your assumed unused sick leave amount. You can give it a specific date, and then it'll show you, what your total service would be if you want to work it that way. So it's a tool to take advantage of if you are so inclined. So start thinking about what option is best for you and your family. It's easy to generate your own estimate, and you can get it right away. Again, if you're within 2 years, you can have in-person counseling in Atlanta or Macon, or we might be at your school system. That's very random. You could check with your HR office to see if we're coming out there, but it's a limited staff. And there's, over 200 different school systems. So it's kind of hit or miss. The easiest thing is to set up an appointment in Atlanta or Macon, or you can do it virtually on Microsoft Teams. So let's talk about creditable service. Remember, this was part of the formula that we looked at earlier, and it's composed of 3 parts: your day-to-day membership service, unused sick leave credit, and purchased service. Your membership service is month to month. We don't look at your teacher contract. We don't look at the school year. We look at our fiscal year at TRS, which starts July 1 and goes through the end of June. And, once you have 9 months, you have 1 year with TRS. 9 months equals a year in that July to June period. You don't get extra credit if you work 10, 11, or 12 months. But those months can be included in your high consecutive 24 months of salary, but you don't get extra service credit. Okay. Once the clock hits July 1, you start accruing credit once more. Now, the typical teacher on a 10-month contract will get 12.5 days. If you're like an administrator, you can get up to 15 days a year. So you can see in a backdoor kind of way that if you don't use your sick leave and you're a 12-month person, you'll accrue more sick leave than, say, a classroom teacher. And you would get more from TRS because of your contract type, assuming that you do not use, any of your sick leave. We do not award the sick leave on your first check because we're busy doing the calculation right after you retire, but you are made whole again with a separate check for any time that was missed, plus future checks. I'd say after, by your second check, you would have the sick leave included in your regular monthly benefit. This doesn't happen so much anymore, but if records are missing, we're going to compute an average for you based on the records we do have. We'll take estimated days and add them to the recorded days and get you a total. And then you can go to this chart. It's on our website too. Don't feel like you got to frantically write any of this down. If you go to our website, www.trsga.com, you can go to the publications tab and click on the members guide. And I think it's page 26 or 27 of the members guide has the sick leave chart on it. But you can see here it's a minimum of 60 days to get any credit. And remember, we have a 9-month year. So if you have 60 to 69 days, that's 3/9 of a year or 1/3 of a year. So we're going to add 0.333 years to your total service. If you had 170 to 189 days, that's 9 months or 1.0 years. So if that was you, you could work 29 years, have a year of sick, and get up to 30 and retire, or you could work 30 years, have 1 year of sick, and get a 31-year benefit. To give you an example, if you had 190 days, that would be 10 months or 1 year and 1/9 of a year. So we would add 1.111 years to your total. It's not uncommon, if you work 30 years and you don't call off any or not much, you'll have in the neighborhood of 2 years or 18 months of creditable service. You could work 28 years, have 2 years of sick, and retire with 30. So unused sick leave clearly has quite a bit of value to you. And that's why we always encourage new teachers not to use it if they don't have to, because it can equate to some real extra money for life in retirement that's eligible for cost of living adjustments. Okay, let's move on to service purchases. As the name implies, this is time that you can buy and add it to your creditable service account, just like you were doing your Georgia classroom work. But of course, it's all defined under the law, and you've got to be eligible to buy it. You're never under any obligation to buy it, but I can say in many cases, when you run your cost benefit analysis, it may only take you 3 or 4 years to get your money back through a higher benefit. And then for the rest of your life, you're going to be getting more per month. So it's worth looking into. A lot of people see the cost and think it's too much, but they're not also looking at the extra money they're going to get for life. So look at both sides of the equation to determine if it makes sense for you. This does involve some math and calculating. So you may want to get help from your licensed financial advisor, certified financial planner. A good place to go is if you're in a 403B, take advantage of that 403B rep, whether they're from Fidelity, Lincoln, Corebridge, whatever it happens to be. They've got software that can help make the best decision for you. You're never, like I said, under any obligation to get this. It only takes your time and effort to get the paperwork done and in. Then once you get the cost, you can decide if it is worth it for you. Probably the most common one is what we call TRS withdrawn service, where you worked for a while and you quit and you pulled the money out of your account, out of your bucket. Well, you later decide to come back to Georgia covered work. Once you've been back 3 years, we allow you to buy back the time you cashed out on. You simply give us the money we gave you plus interest. Then you get your time back, plus you get the unused sick leave that was attached to your withdrawn service. You might have taught at an out-of-state public school or college. You can buy up to 10 years of out-of-state public service, provided you're not going to be getting a pension from that other system. If you are, you'd have to give it up to move it over to Georgia. But a lot of teachers might have a year here, 2 years there. Why not merge that time into your Georgia account and get lifetime pension money for that year you might have had in Alabama, for example? If you were a state employee in Georgia under ERS for Employees Retirement System, you can buy that time. Maybe you were active duty military service and not getting a pension. You can buy up to 5 years of active duty military, not reserves, but active duty. If you taught in private school here in Georgia, that was accredited, you can buy that, but it's extremely expensive, as is what we call airtime. You can buy up to 3 years of airtime in conjunction with a retirement because you want to get out. You want to get out sooner. You can just buy time, but if it was that simple, everyone would do it. It's extremely expensive. For every year of airtime you want, it costs in the neighborhood of 1 year of your TRS benefit. So if you were going to get $40,000 a year from us, 1 year of airtime would be in the neighborhood of $40,000. But that's not how it's actually costed. We do a present value of a future cash flow analysis. But it gives you a ballpark idea of how we calculate the cost. That's out there too. So, maybe you've worked 29 and a half years. You don't want to come back for that last half of a year. You could buy 6 months of airtime or whatever you need to get up to 30 and then retire at that point. Now, in the members guide that I mentioned earlier, there is a whole section on service purchases and tells you how to initiate all these things, which is essentially a form that you fill out. Other than TRS withdrawn, you can just call the TRS office and they can initiate a withdrawn service purchase. If you do buy service, it counts just like classroom time or whatever you do with TRS. So you could certainly retire earlier. Some people buy it to avoid an early retirement penalty. It does increase your benefit, that 2% a year, just like your normal time work does. But the longer you wait to buy it, the more it's going to cost. Every year, the cost goes up 7.5%. So it may behoove you to buy sooner than later. You also can't buy after you've retired. You've got to execute these things and close the deal prior to retirement. That last bullet there, we haven't covered. Some of these service purchases take a while to execute, principally the out-of-state teaching service. I've seen that take 2 years, sometimes even longer, because that out-of-state system is not actively cooperating. So, don't think this is the sort of thing you can do a few weeks before you plan to retire. Better to get it done right away, plus it'll end up being cheaper for you too. For your convenience, we do now have an upload and download tool, so you can scan documents and send them to us. We'll also download forms to you through your TRS account. And you can find that on your account desktop. Okay, our last issue of the day before we take questions is primary or beneficiary issues. That includes primary and secondary. What's the difference? What if you pass away while you're working or in retirement? And we'll have some recommendations. So a primary is the person who's going to get the monthly lifetime benefit. With one rare exception, secondaries don't. The only thing secondaries can get is any money that might be left in your bucket when both you and the primary beneficiary are deceased. If that happens, what's ever left in your bucket of money, your contribution account, contributions and interest, if there's any money left in there, we refund it in a lump sum to your secondary. It's not a lifetime monthly benefit. So if you want multiple people to get a monthly benefit, you've got to list those people as primaries. Secondary is only there so we know how to distribute any money that might be left when all the primaries are deceased. What if you die while you're working or 4 years after you terminate employment, waiting to turn age 60 and start your pension? We have teachers in that category where they're vested. They have 10 or more years, but they quit teaching before they turn 60. They leave their money with TRS, and then the pension starts at age 60. So if you die in that 4-year period after quitting or while you're working, that's called a death in active service. If you die in active service with less than 10 years, all we can do is refund the money in your contribution and interest bucket in a lump sum. But if you're vested, and I think most people on this workshop today are vested, there's extra protection for your beneficiary, because they can either take option 2, which is that rich payout, lifetime payout, or they can take the money in your contribution and interest account, or bucket. They legally have a choice of one or the other. Now, in the unlikely event that you die in active service and there's no surviving primary beneficiary, in a death in active service, the secondary gets promoted to the primary and can have option 2 or the money in your account. When might that happen? Well, the more common one would be a car accident where the active teacher is in the car with, say, their spouse who's their beneficiary. They both in the car accident. Then we're going to go to whomever you have listed as secondary and give them the same choice of option 2 or the money in your account. So it's important that you have listed at least primary and one secondary, and that they're 2 different people. Okay. Okay, now we have to read our situation. We're no longer in active service. We are retired, and you're getting checks from us. And your question is, when can I make a change? Well, it's very rare. You can only do it in cases of death and divorce. Now, if you have the max plan, you can change options or you can't change beneficiaries after you've retired. But if you get any of these month payout plans 2 through 4, and you have one beneficiary, and that one beneficiary dies, we do allow a change of beneficiary or plan. If there's a divorce, you can change beneficiary plan. But if you do make a change, we recalculate your benefit, and in most cases, if not all, it will go down. So you may not want to add a new beneficiary, for example. You could go without one. but you do have an opportunity to make changes with one beneficiary. Now, if you have multiple, it's more restrictive. You can't change plans or beneficiaries, and we don't know what's going to the remaining beneficiaries. So say you had 3 kids, one of those 3 passes away before you, we're not going to increase what's going to the remaining 2 children, and you can't bring back another or add a different beneficiary. Now, however, divorce, we do allow you to take the divorced spouse out, then you can relocate to the remaining beneficiaries. So you know, increase what's going to those remaining beneficiaries. But again, we recalculate your benefit. Right? We have to pay the people that are listed on our forms. Things like wills, divorce decrees have no bearing on who we pay. So if you get divorced, make sure you update your records, because if you don't and then you pass away, we have to pay the divorced spouse. And that happens every year. If you want to designate a minor child, that's fine. If there's still a minor when you pass away, we'll have to obtain court-appointed legal guardianship papers so we can pay the child through the guardian. If you retire, passed away within 30 days, fall due to option 2. So that helps out beneficiaries, because most people take the maximum and there wouldn't be any fleet paid. So make sure your beneficiaries are currently up to date. If you have multiple beneficiaries, you can split it up any way you want to, as long as it equals 100. We can't pay a monthly fee to an estate. All we can give an estate is a lump sum distribution. So if it's currently have an estate, you may want to go in there and change it to that named individual. All we can do is a lump sum distribution to an estate. So make sure that gets fixed if that includes you. Okay, remember to set up an appointment if you want one. We can't give you specific advice. We're not licensed or insured to do that. So look to your 403B, 457 representative, or any outside licensed financial planner. Your various checks are going to be a direct deposit around the middle of the month. All subsequent checks are direct deposit at the beginning of the month for that month. So next step is get excited, because you're almost there. And that concludes the PowerPoint. Tony, are you any questions you want me to answer?
Yes. Do we have questions for Mike? Is everybody clear on sick leave and beneficiaries and everything you need to make the right decisions, and you understand that you need to set up an appointment with TRS before you retire? It can be virtual or in person. And there is still an option. Yes. There is still an office in Macon, right, Mike?
Yes, there's in Macon, north of downtown, right off I-75, off Arkwright Road, and then there's one in Atlanta, just north of the Georgia Tech campus.
Right. So you can have that in-person time with TRS to make your plans and that kind of thing. So,
Right.
All right. Well, Mike, you are a rock star. We always look forward to this. Thank you so very much for joining us. And giving us all this useful information, and we look forward to seeing you again in January, hopefully.
Great. Take care and have a great weekend.
Thank you. You too. Okay. We talked a little bit about, we had a video from Medicare.gov on the parts of Medicare, and there are a few other things that you need to know. And one of those things is that your Medicare Part C options, your Medicare Advantage options, are available to you through State Health Benefits Plan. You never, ever, 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 ever want to leave State Health Benefits Plan, because once you leave, you cannot return. And the plans that are available to us are not available at that price through any other options. So you'll hear about all these Medicare Advantage plans on television and that kind of thing. It's very important that you understand that you get your Medicare Advantage through State Health Benefits Plan, and the premiums come out of your pension. So let's talk for just a moment about working past 65 with Medicare. When you turn 65, even if you're still working, you want to apply for Medicare Part A so that you don't face a penalty, because there is a penalty if you do not sign up for Medicare before you turn 65, within 3 months of that time. Let's see. You don't have to pay a premium for Part A. There is a premium for Part B, but if you or your spouse is still working and you have health insurance through an employer, then you can wait to sign up for Part B. There will be a premium. It comes out of your Social Security check, or you can pay it directly to Medicare if you have not started drawing your Social Security yet. And it's important that you avoid the penalty, because that's a permanent penalty, just like with Social Security. The link between Social Security and Medicare is that once you start drawing your Social Security, your Medicare premium is paid from your Social Security directly. It's important that you understand that when you sign up for Part A and Part B, you're signing up for traditional Medicare. Through State Health Benefits Plan, you will be able to get Medicare Advantage, which will also include drug coverage. The plans that are offered through SHBP also include vision and hearing. So you'll be able to go see an ophthalmologist or an ear, nose, and throat specialist, an audiologist, and that is covered by your insurance. If your employer coverage is ending, check with your current coverage when your current coverage ends and sign up for Medicare about a month earlier. If your employer coverage is changing, check your benefits administrator to see what you'll need. Remember that Medicare Part A is hospital insurance and Medicare Part B is medical insurance that covers doctor's visits and so forth. And then Medicare Advantage also includes prescription coverage, vision, and dental. You'll be able to see an oral surgeon covered under Medicare Parts, Medicare Advantage. I am not an expert on Medicare. Our presenter ghosted us. And so I wanted to make sure that you heard at least a little bit about Medicare. I'm going to put the link to medicare.gov in the chat. And that is a site that will answer all of your questions. There are several videos for you to watch. And at our next pre-retirement seminar, we will have a presenter from the state of Georgia who will do a thorough presentation on Medicare. So that's January 24th, our next pre-retirement seminar. Are there any questions about anything you've heard today? All right, Patrick, I'll let you say goodbye to everybody.
Really appreciate everyone being on here. There's a lot of upcoming stuff. Make sure you look at our newsletter. Tony, don't you want to mention a little bit about our little excursion to North Carolina and what's
GAE Retired has a campaign lab campaign, an education piece, which is educate is one of the 7 verbs that our president Becky Pringle told us to act upon. And we are doing an education piece for active educators called How to Support LGBTQ plus students and Not Lose My Job. We will roll this out to the local presidents and the UDs and the ARs, and you can sign up to have this 30-minute training at your local meeting, virtually or in person. So please contact me. I will put my contact information in the chat. Can't type and talk at the same time. And we'll be glad to roll this training out to you. We were in Charlotte, North Carolina. While ICE was there, there was ICE action in Charlotte. It was terrible, but there were protests, citizens protests that walked right past our hotel, and most of the participants in the training left the training and joined the protest. We are on the mark as retirees for making sure that we protect our most vulnerable students and their families. Patrick, is there anything else you would like to add?
Oh, I just think it's wonderful. Just remember our RA, the GAE RA has been a week earlier. It still will be at the Renaissance Hotel this spring. So keep that on your calendar so you won't miss it. And with that being said, we look forward to any of you joining pre-retirement. Save you some money so that when you flip over, when you retire, you will automatically become a retired member of GAE, and we would love to have you. And with that being said,
contact me if you need to know how to apply to become a pre-retired member.
Thank you, Tom. And I want to give Tony kudos because we heard about the repeal of GPO WEP. If it had not been for her mouth, NEA would not be where they were, and we would still have that in that penalty. Thank you for that, Tony, and the applying for the campaign lab grant. We have a lot going on with retirees, so I want to wish everyone a very, very happy Thanksgiving, and we have lots to be thankful for.
Patrick,
Still
there's
got a
a
lot of work.
question. There's a
Yes.
question. We do not have online membership options for retired, but you can get a membership form at gae.org/retired. And you can, it's auto-corrected for me. Let me try it again. gae.org/ and you can go to that website and download a membership form for pre-retirement. And right now, if you join, you can make 10 monthly payments of $45 a month. And when you retire, you'll be a lifetime member.
And believe me, all the only way it's going to go is up, because when I joined, it was $350, and I've been smart and done it when it first came out. I would have gotten it for $250. So get it while the going is good, because prices are going nowhere but up. But with that being said, thank you, and I do wish you all a happy Thanksgiving. I've got thankful for. And thank you for those of you that know what situation I'm in and all the thoughts and prayers. And thank you, Tony, for doing an outstanding job.
All right, everyone. Have a great Thanksgiving. Have a great Saturday. Bye-bye.